right, sir, you're Dustin Knight, and Mr. Knight's case in clause number 25, DCCR 1911 is set for trial to begin with jury selection next week. And what is the announcement?
We're ready, Judge.
State's ready.
And obviously, the age looks young, but I know that was because I think of a re-indictment. So you'll know tomorrow the order. It's likely to be at least close to the top, depending on one child case. So if anything changes, let me know before tomorrow. Otherwise, stay in touch with Mr. Gertz. He'll let you know when you need to be back next Monday.
Sorry,
Yes, ma'am.
Judge, just clarification for Mr. Knight's sake. I know Mr. Gertz has been busy next door in trial with Ms. Moore last week, I believe. I sent him a lengthy email, including an updated discovery certification, asking about an expert. I had filed the motion. I don't intend to jump up and down about a time period. I just asked it at some point in time. I feel we will communicate this week about that issue. I did receive some additional evidence from the ID unit that I don't know will be pertinent to the trial, but in abundance of caution, of course, I will make it available in discovery to Mr. Gertz. I've spoken with his assistant, Ms. Rogers, already this morning. She's going to bring a terabyte to have that copied over and hopefully have it to him. If not this evening, by first thing in the morning. I just got it last night myself.
Okay.
If there are any additional witnesses to be added to the statement, of course, I will let Mr. Gertz know that timely. I have filed several, just standard boilerplate motions, Judge, that I believe could be addressed either prior to or just following jury selection. No issue with those that I foresee.
Okay.
Sorry, I'm just trying to give
Yeah,
the court kind of an
good.
update. If there are any issues, I think that might present themselves. I've done a little bit of research on some case law that I would have available to the court if in fact those issues become pertinent to the case. I would ask Mr. Gertz just as a courtesy, and I'm happy to work on it, but as the court knows, I need a little bit of time if there are any redactions, et cetera.
Yeah.
That he would
I
like.
just need to look at the new stuff and see.
Sure. If
Okay.
there are any redactions, if there's anything he feels like he's missing, I have kept in contact with both of his assistants while he's been in trial, and they know how to reach me day or night.
Sure.
And I'm happy to get him timely, whatever it is that he thinks that he needs.
Okay.
And Judge, I also want to just say for the record, Ms. Malfino has extended an offer in this case that we previously rejected. I just want to be clear that she has informed me that if we did not take the offer today, and I've communicated to Mr. Knight, and he understands that that offer would be off the table. I know it was off the table already, but it's
But for sure
it's
today,
really off the
it's
table.
really off the
Really
table today. So, all right, so I will number the case, tomorrow after docket. You guys will know the number and the trial order for next week. Obviously, if there's anything, I'll be around this week. So if there's anything you guys need, depending on that trial order, we can take care of it even, before next week if we need to.
We'll be ready. Thank you,
Okay.
Judge.
Sounds good. Thank you. And then I have signed a dismissal in Shay Morgan, cause number 24, DCCR 2102.
If
Thank
they
you, Judge.
not tendered the remainder of that restitution.
Perfect.
Good morning.
All right, ma'am, you are Catherine Castillo.
Yes, ma'am.
And so Ms. Castillo was previously entered a plea of guilty to driving while intoxicated third or more in 24 DCCR 2458. There was a new offense. We were waiting on the labs. It looks like we've all received those labs at this
Absolutely.
point. And so what is the
I
state?
called Rose PD last week on the 30th. I got in touch with the detective. He was going to have it to us by this week. And that'll give us a chance to get into grand jury.
Okay.
So just reset it one more time. I think we can get it.
And I will
say this, Your Honor.
Okay.
Everything's been evaluated on my end. We have been in communications. I have the PSI, reviewed all the evidence. We're ready to move forward, so we can get on the docket or.
We'll just do a normal reset about 30 days. That'll give you time to get that case indicted, for you to get all of the discovery on that case. And then whatever, if there's an adjustment because of that to the plea or the negotiations, obviously it's concerning. So I'm not sure where the state is. So you guys talk and we'll see where we are at the next court date. Stay in touch with Mr. Pageant so that when he gets all of the discovery for the new case, you guys can go over that. He'll talk with Mr. Smith and so we'll get an announcement and see where we are at that next court date.
And I do have the blood work as well on the new
Okay.
case, so your staff was
All right,
snap and got it to me quick.
perfect. Thank you. Y'all are free to go.
Your Honor, approach.
Yes.
Ms. Lair that we had on the designation docket. We're gonna need to reset it.
I guess a couple weeks, because she already has the money. She just has to go get a cashier's check too.
Let's just reset it 1 week.
Okay.
Giving this defendant's recent.
Hang on just a second. Good morning, you're Carly Davis. Could everyone please hold it down? So Ms. Davis, you were late for court. I forfeited those bonds. I'll recall those forfeitures. It is extremely important that you are on time to court. Do you understand? And so your cases are set for trial to begin with jury selection next week. Is everyone ready?
Your Honor, I think that my client has something she'd like to request of you.
Judge, before we get to that, given this defendant's recent violations of the drug patch, I'd ask that she be drug tested today.
So the drug patch, I have prescription. We've been
Okay.
going, yeah, that we've been doing that. We got the prescription. It's the same one. There's nothing different. Otherwise, I would absolutely agree with you. So you're not driving, correct? Right. So that was part of that agreement. And so what do you have to say?
With all due respect, I have, after our last time in front of you, I had signed a plea rejection. And it was, Mr. Lynch had told me the offer right before we came in here that morning. And you asked if I had signed a plea rejection on the tablet. She stated no, so we went in the hallway and signed it. That plea rejection was different than the one that she had offered me right as we were at the elevator. So I was a little confused and it didn't click until we were already, it was over. I was still here waiting for my Uber and I sent her a text and I never heard anything back. And I've tried to call several times. She finally had texted me about a month later and said she had been out. She would call me the next day. And I can show records of where I've been trying to get a hold of her and.
So what do
Your
you-
Honor, I just have my phone records.
Well,
that-
yeah, it could have
not
been
true.
30 days. I mean, there's not all that adds up because it's only been 30 days since your last court date. Here's the thing. I just need to know if we're going to trial or not. Do you want to, if you want to take a plea offer, then you guys can discuss that this morning and we can get it taken care of. But your case is set for trial next week. I'm not changing attorneys. I'm not setting it for anything. I will order the cases for trial tomorrow after my jail docket. And so you'll know then what the trial order is for next week, but after today, there won't be any plea agreements accepted. Do you understand that? So do y'all want to visit for a minute or do you want to go forward with trial?
Probably.
Visit for a minute? Okay, I'll hold it. Y'all go visit.
Thank you.
Yeah, thank you, ma'am.
Thought beyond this, Cory Anderson, we did rejections.
Okay. I'm gonna need you guys to sign that, please. Good morning. Are you Kaylin Billups?
Yes, ma'am.
And this is cause number 19-32315. Ms. Phillips was previously in court on probation for a deferred probation for aggravated assault with a deadly weapon. And there's a motion to revoke. We were previously here and she entered pleas of true to counts 1, 2, 4, and 5 in that motion. And I've received the updated report. Have you both had an opportunity to review that report?
Yes, sure.
Yes, sir, we have. And after speaking with probation and Mr. Kimler, I think we have an agreement
Okay,
to follow the
the recommendation.
recommendation of safety.
That's correct. Your Honor.
Okay, so
We need to resolve the misdemeanor, which hopefully I can do that this morning.
all right, Ms. Phillips, in cause 19-32315, I'm going to find that you entered your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation. However, probation has made a recommendation and it sounds like everyone is willing to work with you to give you an opportunity to be successful. And so I'm going to go along with that recommendation and continue you on probation. Order that as a condition of your probation, you enter and successfully complete the SAFE-P program, the special needs SAFE-P. That will give you the treatments you need, hopefully, for everything going on, mental health, drug abuse, whatever it is, so that when you get out, you can be successful and you'll have the tools to be successful. It's important that you do everything you're supposed to, make the best out of that treatment. When you get out, you will have aftercare that will also be a condition of your probation. So it's important that you do all of that as well. Do you understand?
Yes.
If not, and you violate again, I can assure you, if you're back in here on another motion, things will not be this easy. Do you understand?
I understand.
Okay, this was not an agreement. You do have some limited rights to appeal. Mr. Kimler will hand that to you. I wish you the best of luck, ma'am. You can go back with the bailiff, and thank you, ma'am, for being here on probation.
Thank you.
Mr. Kimler? Good morning, sir. Are you Jorge Del Fiero? And Mr. Del Fiero, in cause number 25, DCCR 0892, you're charged with third-degree felony offense of assault family violence by impeding breath or circulation from January 31st of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years in prison. Do you understand?
Yes.
And I have here on the tablet, a plea bargain rejection that you've signed with Mr. Kimler. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation, including a no contact with the complaining witness. Do you understand?
Yes.
You have every right to reject that offer and go to trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial? All right, we'll get that done. And Ms. French, is there any reason to believe that that offer would change in any way?
It's gone now.
Okay,
Just to be clear, Your Honor, it's a condition of his bond. There is a no contact with the victim. Is that correct?
there should be.
Yeah.
Yeah, so it's important that if it isn't already, I'm sure it is, a condition of your bond is that you have absolutely no contact or communication with Amelia Adams. That obviously means in-person contact, but it also means sending messages through other people or social media or anything like that.
Did share a child now, so there has to be some internet communication or visitation.
So there are apps you can use, like the Family Wizard, where you don't have to have actual contact, but you communicate through an app that saves everything. It kind of protects both of you so that all communication is saved on that app. It shows it's only about what's going on with the child, pick up, drop off, school stuff, whatever it is. My suggestion would be that you use that. Unless you have some third party, a parent or grandparent or somebody to help. But it's a nice thing to use anyway, really just to protect yourself so that you are, and it's kind of handy, you know everything that's going on with the child. If you have something, you can put it on that. If she has something that's going on, she can put it on that so you can both see what's happening with your child, doctor's appointments, things like that.
So to be clear, Your Honor, communication via the app is not a violation of the bond condition.
Correct, as long as it is only about the child. Now, if you're on that app and you send something that is not about the child, it's saved and we're gonna know about it. So that's the best way and the way that I would definitely approve for you to have contact only with regard to the child.
Yes, ma'am.
Okay, I do want to make sure you understand that after today, I will not accept this plea agreement. It sounds like it's off the table. So if you change your mind later and want to enter a plea of guilty, it would either be open to the court or to some other agreement. You understand?
Yes.
Okay, we'll see you back at trial then. Stay in touch with Mr. Kimler.
You got this good?
All right, Ms. Woodruff, in cause number 26, DCCR 0034, you're charged with the state jail felony offense of possession of a controlled substance, and that's from March 2nd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for a 4-year deferred probation. There would not be a fine. You would be required to follow all of the rules and conditions of probation. This would run concurrently. It looks like you're already on probation for cause numbers 24 DCCR 1710 and 25 DCCR 0426. And I'm guessing that's just because this was
It preceded.
those because of,
Yes, ma'am.
is that your understanding of your agreement?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No, Judge.
It's admitted. Is there any evidence that Ms. Woodruff is not competent?
Yes, ma'am.
And because she's already on probation and this is a
No,
state jail, any
No,
reason?
wait, yes, I do.
All right, so Ms. Woodruff, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea. I'm going to waive the pre-sentence report, find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. You're ordered to follow all of the rules and conditions of probation. And if you do that, again, this is an excellent opportunity. You do not have the felony conviction on your record. Obviously, if you violate any condition of probation, you'll be back in here on this case and the others. And in this case, facing a sentence in prison of up to 2 years. Do you understand? And if you're successful at the end, the case will be dismissed, also just like the others. All right, so I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, man.
Thanks, Judge.
Thank y'all. Good morning. How are you?
Traffic was a little bad coming in.
That's all right. Thank you. Good morning, sir. You're Bart Thibodeau. And Mr. Thibodeau was previously in court and cause number 25 DCCR 0339. Entered a plea of guilty to the state jail felony offense of solicitation and prostitution. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
I had it.
I have, Judge, and if I may,
Yes.
I have shared my feelings with Mr. Ward based on the length of time I've been before your honor. Known, your honor, that this PSI obviously is less than to be desired. Obviously, Mr. Ward and I neither one knew about the lengthy Calcasieu Parish issues, which can be supported by the fact that there's no disposition on them. So I'll
Right.
refer to what you think is best.
It's very difficult over there,
Yes, it is.
unfortunately. But obviously, Mr. Thibodeau, you've been in and out of trouble in court since 1980, no, since 1987 over in Louisiana. And now we're here and starting in Jefferson County. Where do you live?
Sulfur.
Okay. Are you on any kind of probation currently or parole or anything in Louisiana?
Judge, obviously, our thought in offering the plea on the solicitation case was so that type of behavior would be flagged rather than necessarily the drug. That somebody would see it. over
Yes,
there.
no, I'm fine. I don't disagree with that. I was just, I guess the only, not the only, an issue that I have is that we don't know if there's an actual felony conviction. We just know that there's been some felonies. Those are typically mostly back in the 90s, other than the one. The obstruction of justice over in Calcasieu Parish. It looks like in 2022, there was a 2-year probation. Did you successfully complete that? All right. Anything else?
No,
All right, so I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow this agreement. I'm going to defer all proceedings and place you on probation for 4 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have this conviction on your record.
This is one of
and
the most important moments in the entire hearing because the judge is drawing a very hard line about accountability and courtroom expectations. Notice how clearly the court explains the no contact condition and the risks tied to violating bond restrictions. Even something as simple as a message sent through social media could become a major legal problem if it crosses the boundaries set by the court. The judge also makes another critical point here. Once a plea deal is rejected and trial preparations move forward, those earlier offers may disappear completely. That changes the entire pressure level for a defendant. Suddenly, the
conviction on your
decision...
record, and if you successfully complete the probation, at the end, the case will be dismissed and you will never have this felony conviction. The other side of that, though, is if you violate any condition of probation, which based on your criminal history, I have some concerns about you being successful. I hope you are, and I hope you change whatever it is that's going on in your life and it's been going on in your life. But if you violate, you're right back in here. You'll be convicted. You'll have a felony conviction. You can go to the state jail prison between 6 months and up to 2 years. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. And I will sign that dismissal as part of this agreement in clause number 25, DCCR 0755. All right. Thank you, ma'am. Thank you, sir. Good morning. Are you John Thomas Jackson?
Yes, Your Honor.
And Mr. Gertz, will your client waive the formal reading of the indictment?
You will, Judge.
Do you have your discovery certification?
I will.
Mr. Jackson, in clause number 24, DCCR 1968, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from September 10th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Gertz?
Yes, Your Honor.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? Speak up, please.
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
You have no objection, Judge.
It's admitted. Is there any evidence that Mr. Jackson is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to the probation department, and she's sitting at that desk right over there.
Right there.
All right, so stop and talk to her on your way out of the courtroom today, and then we'll see you back at sentencing. And you'll email the attachment?
Yes, Judge. I need to explain to him about the PSI because I haven't.
Okay.
Talk to him right now.
All right, thank you.
And then here's the dog. So. Thank you, Judge.
You can.
Thank you, Judge.
Yes, ma'am.
Good morning. Are you Morris Williams?
Good morning, yes.
And this is 26 DCCR 0359. Mr. Williams is charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
Announcement is the state and I have been in communication. There's some shared concerns that we asked for a little time to address if we could get another setting.
Any issues? No. All right, I'll just do a normal reset and to give you guys some time to visit. And for Williams, stay in touch with Mr. Jeffries so y'all can visit before the next court date, and we'll see if we can get an announcement then. All right.
Thank you.
Y'all are free to go. Good morning. You're Edgar Castillo. Let's wait just a second for Ms. Alfino to get her file. And excuse me, this is 25 DCCR 1052. Mr. Castillo is charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
Judge, we strangely have all the media in this case, but for some reason, the paper discovery is not showing up on the portal. I didn't realize that this morning. I saw a discovery file. I went and looked and it's got media, which never happens. It's usually the opposite way around.
Right.
So
So we'll just do a normal reset. Mr. Castillo, make sure you stay in touch with Mr. Gertz, make an appointment and visit with him so that before that next court date, you guys can visit. We'll have an announcement of the next court date. All right, you're free to go.
Not extended and deferred off.
All right, y'all had a time to visit. Ms. Delisha, what is the announcement?
We're ready for trial.
Okay, and so what is the state's, which case I guess would be first? The older one, the newer one?
Judge, can I give the court an answer? Maybe I can ask you, please.
Yeah, if you don't mind, Mr. Coleman, and you can have the day, if you'll just maybe email me and Ms. DeLage in a
By
group.
the end of this hearing, the courtroom has transformed into a powerful example of how quickly legal outcomes can shift depending on preparation, credibility, and timing. Some defendants received another opportunity through probation and deferred adjudication, while others watch plea offers disappear entirely as their cases move closer to trial. Throughout the docket, the judge repeatedly emphasized responsibility, communication, and compliance with court orders, especially in cases involving probation violations, bond conditions, and pending felony charges. What stands out most is how every
Still age in
defendant
a group so that I know which one to number
Yes, ma'am.
and she'll know which one to prepare on.
Thank you.
Yes, sir.
Ms. Davis, stay in touch with Ms. DeLage this week so you guys can get prepared. She'll know the trial order tomorrow after docket about noon midday. Okay, all right, you're free to go.
Thank you.
Mr. Gertz, you got Dustin Knight and Ms. Malfino.